All right, we are back on the record in case number DV10-01877, Kieth Mcdowell versus Tonya Mcdowell. The record will reflect that counsel and the parties are present. We have taken a brief recess to permit the court to put its notes in order. First thing I want to say is I would very much like to commend both counsel for the work that you've done here the last couple of days. You have been very professional with each other. You have presented a good case on behalf of both of your clients, and I truly appreciate the way that you've conducted yourself in this case. That being said, the court makes the following findings and conclusions of law. First, the court finds that it has jurisdiction over the parties and all of the issues that have been presented by this case. The court finds that the parties are incompatible in marriage and that a divorce should be granted to the parties, restoring them to the status of separate persons. With regard to the division of assets and debts in this case, the court has heard significant testimony from many witnesses. The court has also reviewed a great deal of documentation. With regard to that testimony, the court finds that the defendant's testimony was not credible. The court also finds that the defendant has or had documents she did not produce. I am specifically referring to the contract with regard to the 2007 loan and the Rivendell business. I am convinced, based on the plaintiff's testimony, that such a document exists. The fact that notes surrounding the document were produced and the document itself was not also is indicia that the contract actually existed and was not produced. When documentation is not produced, the court can draw an inference based on that type of conduct. And the inference that the court draws is that the documentation would be negative to the party who didn't produce it. The court draws such an inference in this case. I find that the defendant in this case usurped a community business. She used the business to benefit herself, her family, friends, and third parties to the detriment of the community. What she suggests here at the end of this case is that she take the business and the business debt and that she leaves the plaintiff with the marital home and the debt against the marital home, ignoring the fact that 50% of that debt is in fact business debt. It was used to start this business. It would not be an equal division of the debt to divide the assets and debt in the way that the defendant has suggested. The appropriate division is that she pay 1/2 of the 2007 debt as a business debt. That debt is in the amount of $53,000, and that's what the court is going to require her to repay. That repayment is payable at no less than $500 per month. It will accrue interest at the legal rate until paid in full. With regard to the issue of rent, once again, the plaintiff testified and the court is convinced by his testimony that he asked for a document in writing with regard to the quote-unquote lease of the property which had been the marital residence. There was no such writing that came into place, but we have proof of a course of dealing in a regular payment of rent in the amount of $1,950. I will note as an aside that while the statute of frauds would normally require such an agreement to be in writing, a party cannot resort to the statute of frauds to commit a fraud. And so the court in this particular case, had the statute of frauds been raised as a defense, would not have considered that defense to be a good defense. When I look at the defendant's bank records, what I see is an outstanding rent amount that was not paid in the amount of $9,400. Ms. Luna is correct in her argument that that was a joint debt, and so it can only be jointly assessed or paid back to the plaintiff. 50% of $9,400 is $4,700. That amount will be paid back to the defendant at the rate of at least or no less than $100 per month, again accruing interest at the statutory rate. With regard to the property division, the marital home is currently the home that the plaintiff resides in. He has indicated he wishes to keep it. The court is awarding him the marital home. With regard to the business, it makes sense that the business be awarded to the defendant. She's the only one who's run it for the last several years. I do not find, however, that the value of the home offsets the value of the business. One reason being that the business itself is an ongoing concern and has value as such. I also took a very close look at the profit and loss statements that were submitted in this case. They include numerous expenditures which were questioned by the plaintiff and for which there's been no explanation by the defendant. They also show a steady increase of income each year, and that increase of income from the year 2008 to the year 2011 was, by the court's math, $134,600. That does not indicate a business that is failing in the way that the defendant testified it was. In fact, if this business were run as a business instead of as a surrogate wallet for the defendant, this business would be far more profitable than it is. The parties have argued that this, both parties in fact, have argued that this is not an alimony case. Frankly, the court could well see that it would be. Taxable income, according to the IRS code, includes meals, benefit to family members, car allowances, gas, housing expenses, many things that are run through the business. It is obvious to the court that the defendant's financial disclosure does not include all of the income or the benefit that she derives from her business. However, the business is not throwing off substantial cash at this point, and this is a marriage of 10 years duration. So any type of alimony award would be something that would be speculative at this point. What I'm going to do is I am going to follow Ms. Mahan's request. She has requested a reservation of alimony of $1 per year until the debt is paid in full, and the court's going to do that. If this business takes off the way it has the possibility of doing, then it is absolutely possible that during that time frame, the plaintiff may come back in and ask for an adjustment, given that this was a community business at the beginning. Now, with regard to the division of other property, the parties shall retain whatever personal property they currently have in their possession. The plaintiff is going to retain his pension. He's not vested in it yet, so any interest in the pension at this point is contingent. The plaintiff is going to retain the debt against the residents. with the understanding that there's additional debt that the court has imposed on the defendant with regard to that. The defendant is going to retain her debt and the debt of Rivendell and the debt of Rohan Ranch and the debt of any other business that she has opened and is pursuing at this time. Obviously, the defendant will also retain the debt that has been ordered just today by the court. The plaintiff has indicated he's not seeking any damages with regard to the state that the marital home was left, so the court awards none. The plaintiff also indicates that he's not seeking reimbursement for the first loan that was taken out in 2005, so once again the court is not going to grant any reimbursement there. To the extent that the 1099s that were issued to the plaintiff are in excess of his portion of the marital amount of the rent, they need to be amended, and a 1099 should issue to the defendant for her portion of any rent that the community benefited from. As far as attorney's fees, the court finds that attorney's fees based on the conduct of the plaintiff conduct of the defendant are awardable in this case. I am going to ask the plaintiff's counsel to submit a detailed Wilfong affidavit. Ms. Mahan, I believe you were present for the bench bar. The most recent one? Not. Then you might want to talk to somebody about what it is I expect. Okay. Because I want it to be detailed. And by detailed, I mean redacted billing statements.
Okay. And were there any handouts at that meeting?
There were not.
Okay.
I need that affidavit within 10 days. I'm going to give Ms. Luna 10 additional days after the affidavit is filed to make any objections based on reasonableness. I will tell you the award will probably not be for the entirety of the fees, but the court is going to be scrutinizing the issue of discovery very, very closely.
Your Honor, will you define what, I wasn't there either, what you mean by redacted? Do you want her redacted like for me, I put review and receipt letter. Do you want all that stuff redacted out, or can she leave that stuff in?
That's in. If she thinks that it impacts the attorney-client privilege, she can redact. I will tell you that the subject matter of research probably does not impact the attorney-client privilege. Conversations, if you say directly what the conversations are about with your client, may. That's where I would expect to see redaction from the billing statements.
Did you say that was within 10 days, Your Honor?
Within 10 days. Ma'am, did you wish to be restored to your maiden name?
I'm going to keep my name.
All right. Then that will be the order of the court. This matter is in recess. Thank you very much.
All rise.